Thank you, Anne. Excuse me. Good morning. I'm Chi Elder, Chair of the Professional Fiduciaries Bureau Advisory Committee. I'm calling this meeting to order at 10:01 a.m. This meeting is being held on March 9th, 2022 via WebEx teleconference and webcast pursuant to Government Code Section 11133 and Executive Order N-1-22. This meeting will be held by teleconference with no physical public locations. I would like to ask our WebEx moderator to please explain the format of this meeting.
Thank you. This is Ann Fisher, and I am the moderator. We will be managing public comment through the WebEx's Q&A feature. When it is appropriate to open up the public comment period, you will see an icon with a question mark, typically in the lower right corner of your WebEx screen, or if you're on a mobile device, behind the 3-dot other options. And if you are a call-in user, you can use *3 to raise your hand. At that point, we will take comments in the order received, and you will have 2 minutes to speak with a 30-second warning. Thank you very much.
Thank you. Item number 2 of the agenda. At this time, I would like to ask Angela to call roll to establish a quorum.
Good morning, everybody. If you are present, please let me know that you're present as I call your name. Chi Elder.
Present.
Bertha Sanchez Hayden.
Present.
Wendy Hatch.
Present.
Elizabeth Ichikawa.
Present.
James Moore.
Present.
And Denise Nellison.
Present.
With 6 members present, we do have a quorum.
Thank you, Angela. Item number 3 of the agenda, I would like to ask the committee members and Bureau staff to introduce themselves. I will start. I am Chi Elder, and it's an honor to serve as the chair of the advisory committee and as a public member appointed by the Senate Rules Committee. I am based in San Diego, California. And as I call your name, please introduce yourself. Bertha Sanchez Hayden.
Good morning. Bertha Sanchez Hayden, Professional Fiduciary Advisory Public Member appointed by the Senate, by the Governor. And I am based in Los Angeles, California.
Thank you. Wendy Hatch.
Good morning. I'm Wendy Hatch, a private professional fiduciary, and I'm based out of Long Beach.
Thank you. Elizabeth Ichikawa.
Good morning. I am the supervising court investigator with the Solano County Superior Court.
Thank you. James Moore.
Good morning. I'm James Moore. I am a licensed professional fiduciary, and I am based in Sacramento.
Thank you. Denise Nelson.
I'm a retired licensed clinical social worker with a specialty in aging, and I live in San Diego.
Thank you. Rebecca May.
Good morning. I'm Rebecca May. I'm the Bureau Chief for the Professional Fiduciaries Bureau. Good morning, everyone.
Thank you. Fred Chan-Yu.
Fred Chan-Yu, DCA Legal.
Thank you. And Angela Quadra.
I'm Angela Quadra, the Program Analyst for the Professional Fiduciaries Bureau.
Thank you. Item number 4, please allow me to briefly address this agenda item. California law prohibits advisory committee members from discussing or taking action on any matter not on the agenda. However, this item offers an opportunity to the public to comment on items that are not listed on today's agenda. Please be aware that public comment during this agenda item should not provide information to the advisory committee members and is not meant to be a discussion between the advisory committee and the public. Though this may seem at times like advisory committee members or Bureau staff are not being responsive, following these guidelines is critical to ensuring the rules of the Open Meeting Act are followed. Before the committee asks for public comments, I ask individuals making comments to not discuss pending complaints, pending licensing applications, or pending disciplinary actions that may come before the Bureau's legal counsel. Such discussions are considered ex parte communications by potentially providing information to the Bureau's legal counsel outside of the administrative record in a case. The committee strongly asks that you also respect the privacy of others by not revealing the names, other personal information, and conditions of any individuals involved in any case or complaint. The advisory committee can receive comments regarding the Bureau's processes in general, but it cannot receive comments on specific cases. If you want the committee to discuss a topic not on the agenda, you may request that item be considered for a future meeting agenda. However, a request does not obligate the Bureau to fulfill that request. If your comment is related to any item in today's agenda, please wait until we get to that agenda item. Comments at this time are only for items not on the agenda. To allow the committee sufficient time to conduct its full schedule of business, public comments will be limited to 2 minutes apiece. Please do not duplicate or replicate comments of a previous speaker. I will now ask the moderator to call for public comments.
And this is the moderator. I am turning on the Q&A feature of WebEx. You will now see a icon of a question mark inside a square, typically at the lower right corner of your WebEx computer screen, or behind the 3-dot other options if you're on the audio on a mobile device. You can type the word comment into the text box and click send, and we will take commenters in the order received, and each person, as noted, will have 2 minutes to speak. I'll give people a moment to locate that feature, and this is to suggest items not on the agenda. And I do not see any requests for public comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Item number 5 of the agenda. Rebecca, would you please read the Bureau's mission statement?
To protect consumers through licensing, education, and enforcement of the Professional Fiduciaries Act by promoting and upholding competency and ethical standards across the profession.
Thank you. Do we have any comments from the committee? Okay. To allow the committee sufficient time to conduct its full schedule of business, public comments at the end of each agenda.
Madam Chair? Sorry,
Yes.
Madam Chair. I think we would need to also give public comment on that. On the
Oh,
last
yes.
item.
Yes, thank you, Fred. I was just letting the public know that comments at the end of each agenda item will be limited to 2 minutes apiece. And if there are any public comments on this item.
And this is the moderator. We've opened up the Q&A feature of WebEx to accommodate any public comments on the mission statement of the Bureau. And I see no requests for public comment. Shall I close that feature?
Yes, thank you.
You're welcome.
And thank you, Rebecca. Item number 6 of the agenda, are there any suggested edits by the committee members to the September 15th, 2021 meeting minutes? Okay. Is there a motion to approve the minutes?
This is Denise. I approve the minutes.
Thank you, Denise. Is there a second to the motion?
This is Wendy Hatch. I make a second to the motion of approving the minutes as posted.
Thank you, Wendy. Any discussion from the committee members?
Madam Chair, this is Fred Chen, Yu, DCA Legal. Just for the record, we are talking about the minutes for the December 9th, 2021 meeting, correct?
Oh, yes. I'm sorry. I don't know why I was thinking September 15th. I'm a little bit behind. Sorry about that. Yes, that's correct. This is from the December 9th, 2021 meeting. Thank you. Thank you, Fred. Do we need to take a vote again to reflect that we're reviewing the meeting minutes from December 9th, 2021? Oh, I'm sorry, December 8th. Do I have a?
This is Wendy Hatch. I'd like to make a motion to correct the motion that we approve the minutes for Wednesday, December 9th, 2021's minutes as posted.
Thank you, Wendy. Do I have a second?
This is Denise Nelson. I second that motion.
Thank you,
Madam Chair, sorry, this is Fred Chen Yu again, DCA Legal. I think the minute says December 9th, actually December 8th.
Okay.
Just for the record, sorry.
Thank you. You know what? Third time's the charm.
Okay, this is Wendy again. I make the motion to correct the motion that we approve the minutes except for the date listed on correction on the actual minute meetings to reflect Wednesday, December 8th, 2021. But other than that, approve as posted.
Thank you, Wendy.
This is Denise Nelson. I second that motion.
Thank you, Denise. Any comments from the committee?
Hi, this is Rebecca. I'm sorry that we had the date incorrect on the minutes, but it's looks like it's correct in the agenda, and it sounds like the motion is correct. So thank you, everyone, for rolling with the punches on this.
Not a problem. Thank you, Rebecca. Any discussion from committee members? Any public comment?
This is the moderator, and we are enabling the Q&A feature of WebEx for public comment. If anyone has a comment on the content of the meeting minutes, you may click on the question mark box and type the word comment in the text box and click send. If you are on a mobile device, the Q&A is behind the 3-dot other options. And if you're a calling user, you can use *3 to raise your hand. And I do not see any requests for comments on the minutes. Shall I close the Q&A feature?
Yes, thank you.
You're welcome.
Angela, would you please do a vote by roll call?
Yes, so a vote of yes would be to correct the date on the minutes to reflect Wednesday, December 8th of 2021. And as I will call you each by name. Chi Elder.
Yes.
Bertha Sanchez Hayden.
Yes.
Wendy Hatch.
Yes.
Elizabeth Ishikawa.
Yes.
James Moore.
Yes.
And Denise Nelson.
Yes.
Great, thank you. The minutes will be posted with that correction to the date.
Thank you, Angela. Item number 7, I would like to invite the Department of Consumer Affairs executive staff to present their update.
Good morning, committee members. I'm Brian Clifford, representing the Department of Consumer Affairs Executive Office. Thank you for allowing me an opportunity to provide a department update today. DCA appreciates all committee members and staff who have continued to serve through a pandemic that has affected all of us in many ways. As California moves past the recent Omicron surge and into a new endemic reality, new state public health guidance has relaxed mandatory face coverings. Masks are still strongly encouraged in indoor settings, and in some high-risk settings, such as healthcare facilities, face coverings are required for everyone regardless of vaccination status. Local orders may be more restrictive to respond to community conditions. Please be aware of changing public health guidance and remember that as state representatives, we are all expected to adhere to state and local orders while carrying out our duties. Regarding remote meetings, on January 5th, 2022, Governor Newsom signed an executive order that extends the sunset date in Assembly Bill 361, allowing boards and committees to meet remotely through March 31st, 2022. I'm happy to let you know that on January 31st, Assemblymember Quirk introduced new legislation, AB 1733, which would permanently allow boards and committees to meet remotely while also providing both virtual and physical options for members of the public to participate. If this bill is passed by the legislature and signed by the governor, it would take place immediately. We cannot be certain that AB 1733 will be enacted or when, so we should prepare for the possibility of in-person meetings after March 31st. Before attending any in-person committee meetings, members must verify full vaccination status with DCA's Office of Human Resources or participate in COVID-19 testing. If any members have not yet done so, please submit your proof of vaccination. Your participation will assist DCA in planning for testing at future meetings. Please do this as soon as possible and do not hesitate to reach out if you need any assistance. Next, regarding appointments and recruitment, whether meeting remote or in person, DCA wants to help keep this committee fully seated with excellent members and diverse voices. Currently, the committee has one vacancy, a licensee to be appointed by the governor. DCA's communications team recently released a new communications toolkit to assist boards and bureaus with member recruitment, available in many languages. Committee members can also encourage individuals to visit the board member resources section of DCA's website to apply for an appointment. Current members will also be eligible for reappointment after January 1, 2023, when you will begin a one-year grace period. Looking ahead, members should consider whether they'd like to pursue reappointment and speak with your bureau chief so she can help with the process. Board and bureau relations can also help answer any questions you have and help you make contact with your appointing authorities. I'd next like to provide an update on DCA's Enlighten Licensing Project. This work group was formed in 2020 to utilize licensing subject matter experts within the entire Department of Consumer Affairs. The group's purpose is to help individual boards and bureaus streamline and make their licensing processes more effective and efficient by utilizing best practices, information technology, and cost-saving measures. The first deep dive into the Board of Registered Nursing has been completed. A report will be released this month with recommendations that can be used by all boards and bureaus to improve their processes. After this successful first round, the work group will soon begin directly assisting another board or bureau. As DCA looks to the future, Director Kirkmeyer continues to lead the department towards continual improvement and excellent service. DCA is pleased to announce that Tanya Corcoran began serving as the department's first Compliance and Equity Officer effective March 2nd, 2022. Ms. Corcoran brings years of hands-on experience with DCA boards and bureaus to this new position. She was most recently the Chief Deputy Registrar at the Contractor State License Board. This position will oversee DCA's Solid Trading and Planning Solutions, Organizational Improvement Office, Equal Employment Opportunity Office, and the Internal Audits Office. Bringing these offices together under Ms. Corcoran's experienced leadership will be a tremendous benefit, allowing DCA to better identify and analyze emerging issues department-wide and provide timely solutions to DCA's divisions, boards, and bureaus. And finally, I'd like to address training and reporting requirements for committee members. Each year, committee members are required by law to file a Form 700 before April 1st or face penalties from the Fair Political Practices Commission. DCA requests that you file as soon as possible. If anyone needs assistance, DCA's filing officer and legal counsel are available to help. Additionally, committee members who are recently appointed or reappointed need to attend the board member orientation training within a year of that appointment date. You can register for the BMOT through the Learning Management System, which is DCA's training portal. Live virtual trainings will be held on June 15th and October 12th. As always, the Board and Bureau Relations team at DCA is here to help, and if there's anything we can do to assist, please reach out. That concludes my presentation. I'm happy to hand it back to the chair. Thank you.
Thank you. Do we have any comments from committee members?
This is Denise Nellison. I understood that our advisory council members did not need to do the 700 form. Is that correct?
I think they do, but you know what? Let me just double check on that particular item, and then I will get back to Rebecca, who can share that information with the committee members.
Hi, Brian. My understanding is that they do not have to form 700, but if we want to just double, triple check, I can advise.
That's good to know.
Off an email afterward. Yeah.
Thanks, Rebecca.
Thank you.
Any other comments from committee members? The only comment I would like to add, Elder, is I think that the push to have the board and bureau meetings virtually, as well as offer the in-person and hybrid for the public to attend, I think that is a very innovative strategy, and it also helps to minimize costs for the bureaus and boards as well, in allowing us to still get the information out to the public. And if there's anything that we can do to help, to encourage that or support that, please let us know.
Thank you, Chair. Yeah, I think that's shared throughout a lot of our boards and bureaus.
Great. Any comments from the public?
This is the moderator, and we've opened up the Q&A portion of WebEx to accommodate public comment. If you'd like to make a comment, you can look for the question mark icon, type the word comment into the text box and click send. Or if you are an audio-only participant, you can raise your hand by pressing *3. We do have a request for comment from someone logged in as James Counts. James, I'll request that you unmute yourself so you can make your comment, and you have 2 minutes. And you're unmuted.
It's a question, if possible. You mentioned, I think you said for the panelists, for in-person meetings, would have to submit vaccine verification. Would that apply to the public if they wanted to attend a public meeting?
No, I don't. That is only for the committee members.
Thank you.
And I do not see any other requests for public comment. Shall I close that portion of the meeting?
Yes, thank you.
You're welcome.
And thank you for your comments. Item number 8 of the agenda. I would like to invite the Department of Consumer Affairs Budget Office to present the budget update.
Thank you, Chair Elder, and good morning. My name is Harmony DiFilippo, and I am the Budget Analyst with the DCA Budget Office. I want to thank you for allowing me the time to present the Bureau's expenditure projections, fund condition statement, as well as answer any questions. Today, I will be speaking to Agenda Item 8, including pages 7 and 8 in the meeting materials. I would like to start with a quick update regarding the current year and budget year. On January 10, the governor's budget was released, which provided updated budget numbers for the Bureau that includes incremental adjustments to current year, 21-22 into the base budget for budget year 22-23, which was provided in the last meeting. So today I'm going to start with reviewing the expenditure projections on page 7. Okay. So this is an overview of the expenditures as of FM6 with projections to year end. It's broken out into 2 sections, personnel services and OE&E. The total projection for personnel services is approximately $405,000. The total projection for OE&E is approximately $213,000 for an overall total projection of $618,000. And it looks like, I'm not sure if everyone can see from this presentation, it's kind of broken up, but it's also included in the meeting materials.
And this is the moderator. For everyone's reference, you can scroll up and down on your own screen individually within any given page. Thank you.
Thank you. Next, I'm going to review the fund condition, which is on page 8. So this gives you a 4-year view of the Bureau's fund, and I'll speak to each section briefly from left to right and top to bottom. So the first section or column includes your prior year actuals for 2021. And you can see there the revenue for 2021 actuals. And then next, in the second column, we have our current year, which includes the projected revenue based on FM6 projections. And then the last 2 columns, we have our budget year and our budget year +1 revenue projections. And these projections are based on the governor's budget, with the exception of the income surplus, which is formula driven. And you can see that they are similar. Moving down, we have the expenditure projections. Again, the first column starts with your prior year actuals. Then our second column has our current year expenditures. And again, this is based on FM6 projections. And then our last 2 is budget year and budget year +1. Those projections are assumed realized, meaning that the Bureau expends to the full appropriation. If the Bureau expended to the full appropriation in budget year and budget year +1, then the Bureau would become insolvent and would show a negative reserve balance at the end of budget year 23-24. I would like to point out the structural imbalance displayed in the fund condition. As you can see, the expenditures, starting with budget year and budget year +1, are more than the revenue. This shows the Bureau is spending more than they are bringing in. I am currently working closely with the Bureau Chief, Rebecca May, to address the decline in the fund. We will continue to monitor the budget and provide monthly updates to Bureau Chief Rebecca May. This concludes my presentation, and I am happy to answer any questions. Thank you all.
Thank you, Harmony. Do we have any comment from committee members?
Yes, this is Wendy Hatch. I am very, very concerned at the projection of the Bureau going insolvent. And I believe the governor is going line by line to review the budget. But what typically is the solution to this deficit, and is it the deficit is incurring by the AB 1194 due to the new restrictions and guidelines that particular assembly bill set up, that the Bureau is going to have to hire more people, and then it opens it up for more sanctions and citations, so more experts and more attorney general time is going to be required?
Hi, this is Rebecca May. I'd like to answer if possible. So yes, AB 1194, it will significantly increase the number of complaints and investigations the Bureau conducts, which necessitates additional staff. It also will increase the number of enforcement actions taken by the Bureau, which necessitates additional funding for Attorney General and subject matter expert costs. So in this projection, or do you mind moving to the fund condition, Anne? Thank you. So in this governor's budget, this reflects a budget change proposal that would assist the Bureau in meeting the mandates under 1194. So presuming that that budget change proposal is okayed by the legislature and okayed by the governor's office, that's what would basically authorize the Bureau to then have this spending authority to fund the new requirements under AB 1194.
Can we, as a, you know, I understand, you know, the previous speaker who was talking about how if we're trying to get that emergency passed through, that Bureau meetings and everything can still be held virtual. If this particular Bureau is running so much at a deficit, is there any way we can choose to only go virtual instead of spending the money for the committee members to fly to Sacramento, or, you know, even if we went back to the different sites, to having a representative fly to the different sites? Can we as a Bureau itself make a motion to keep the virtual meetings so we can stay within our budget?
Yeah, I wish that we could. Unfortunately, we do have to follow the law in the Public Meetings Act. We definitely try to, you know, implement the law as inexpensively as possible. So fingers crossed that the Quirk bill will get passed and signed. That'll allow us to continue to meet virtually. I think that sounds like there's support for it. That being said, travel costs, while not paying for travel costs would really be very helpful to the Bureau's bottom line, it's not sufficient enough to cover the cost of an additional employee or additional Attorney General's fees.
So if we don't get approval on getting more funding, then basically the solution is our licensing will be going up. The fiduciaries licensing will be going up.
Yes. The Bureau will need to raise fees, application, initial licensing, and renewal fees in order to implement the new mandates created by AB 1194. And like other licensing entities, the Bureau is wholly funded by its licensing population and does not draw monies from the state's general fund. Since the Bureau's inception in 2008, fees have never been raised, although the cost to the Bureau for rent, salaries, benefits, and other costs of doing business have certainly increased over the years. We are working with the department to determine what the exact amount of the fee increase would be and how it would be distributed between applicants and existing licensees.
I'm just playing the devil's advocate here. Being a committee member, I'm for the consumer, but as a fiduciary, is there, since we don't have the broad base that was expected upon licensing, because only the sole fiduciary is the one that is required, but there's other professions out there that don't have to carry the licensing and or the cost, i.e. attorneys, CPAs. Isn't there any way that legislation or the Bureau itself can open it up to have other professions be required if they're going to be acting as a fiduciary to chip into the Bureau's budget? And again, I'm playing devil's advocate here.
Yeah, no, that's a fair question. If there's complaints about attorneys or CPAs, then those complaints would go to their respective licensing boards.
But even if they're acting as a fiduciary, I mean, yes. The Bar Association won't care about their duties as a fiduciary if they're, I don't know.
Unfortunately, if they're not licensed by the Bureau, we can't request money from them or take fees from them.
There can be really no disciplinary action brought against the profession like the CPAs or the attorneys that don't carry the fiduciary license if their actions as a fiduciary. There's no disciplinary board that can address it.
They would have to be disciplined by their own licensing board.
But they'll say that that doesn't cover in their licensing. So, oh well, I'm sorry.
Oh, it's fair. Fair question. So I will also say that I know that it looks scary, but we're not at current time, we're not expending over our budget. These are projections. These are projections. If the governor's budget is approved as it currently stands, then our Bureau would have the authority to hire people and to spend more money. We'd have extra spending authority, but we would not have those dollars in essence. So we would not spend dollars that we do not have. But it's kind of a slow moving process. So we get the authority first, and then we seek out the revenue to fulfill implementing the new mandatory statutes under 1194. So a potential fee increase would have to happen under regulations. So the fee increase would require promulgating new regulations. So it would occur probably in the next year and a half or so. The Bureau will notify the public via its interested parties email list when the proposed regulation is filed with the Office of Administrative Law, and the public, of course, would have an opportunity to comment about those regulations during the public comment period through that process.
This is Denise Nellison. This is rather discouraging. You know, you can see that, you know, you charge greater fees, you might have fewer people want to get licensed. Is there no other avenues for us to raise revenue?
So like, as I said earlier, we are, as a licensing entity, the funds that the Bureau takes in are wholly borne by licensees and by applicants. And that's just the way it's structured. You know, for the other licensing programs are the same, like the medical board. It's their licensees that pay for the funding of their board. Essentially, the professionals pay for their own regulation. And until that is changed somehow, this is unfortunately how it works. And I do hear you about concerns about drawing folks into the profession if it's expensive to get in. I think that's a legitimate concern. Unfortunately, for the Bureau, this is because there are new statutory mandates, we are required to implement them to the best of our ability to identify what the costs will be, to identify where that funding will come from, and to proceed as directed. And we'll continue to have time to discuss this. Like I said, none of this is immediate. I mean, it's all in terms of government moving quickly. It is immediate or slowly, but it's not like the increase is going to happen in a month. So there'll be additional time for us to talk about this. There'll be certainly time through the regulatory process to hear from the public as well on that process.
Thank you. This is Chi Elder. I was going to ask, what is the time frame for the Bureau to begin, or for the boards and bureaus, or the Bureau to begin implementing the new mandatory statutes? And then also, what would the timing be in looking at raising fees and as well as looking at other strategies to be able to draw in more revenue, such as more active recruitment of new applicants and just more proactive. I mean, you're already doing the outreach, but other strategies that we can employ.
So the regulatory process generally takes about 18 months to 2 years, and in a case like this where we're looking at the fund being insolvent pretty soon, hopefully we can move as quickly as possible through that time frame. Although I don't think it'll be before a year to 18 months that we would reasonably see a fee increase. Provisions of 1194 that will certainly increase our complaint volume are anticipated at the start of in January, because there are some provisions in that bill that take effect in January, and those are the bulk of what we think the complaint volume will be driven by. And then, yes, we'll be talking about the strategic plan, or our next strategic plan, further on down in the agenda. And I think that would be a good opportunity for us to focus there on how to increase outreach and help see how we can help draw folks into the profession.
Thank you. Any other comments from committee members? Any public comments?
And this is the moderator, and we've opened up the Q&A feature of WebEx to accommodate public comment. If you'd like to make a comment on the budget report, you can look for the question mark icon, typically in the lower right of your WebEx screen, or behind the 3-dot other options if you're on a mobile device. Type the word comment in the text box and click send. You can also raise your hand by pressing *3 if you're on a dial-up connection. And we do have 2 requests for comment. First will be someone logged in as Gregory William Honegger. I'm going to send you a request to unmute your microphone, and you'll have 2 minutes to speak. You're unmuted.
Good morning. Gregory Honegger, a CPA for 40 years and a fiduciary for about 8. But I think the fact that we cannot incorporate as a trustee, as a fiduciary, is limiting the amount of people that will be fiduciaries, period. So I know I brought it up to PFAC and et cetera, and I know there's some regulatory issues with wanting to sue our personal net worth as an individual. It's the only profession in California that cannot incorporate, and I think if you were to address that, I think you would find more fiduciaries.
And our next request for comment comes from James Counts. James, I will send you a request to unmute your microphone, and you will have 2 minutes to speak. And you're unmuted.
Thank you. Also, for disclosure, I'm a CPA, and if Fiduciary Bureau wanted to have CPA as licensees, it would ultimately be the only purpose is to get license fees. We do anything wrong, whether it's only CPA work or fiduciary work or anything, we're subject to discipline by the California Board of Accountancy. So we are subject to errors we may do as a fiduciary. Second item is I verified a few minutes ago the handouts, especially this budget information, is not available to the public. I couldn't read it on the screen because it's so big. Even though I can zoom in, then I lose the right side of the page. So if the handout with in an electronic file could be made available to the public on your website, I'd appreciate it. Comment, you're between a rock and a hard place as far as this revenue, because you're going to have to raise revenue, 50, 60% over prior in order to make up the deficit. And the longer you wait, the more you're going to have to make it up. And then you raise your
30 seconds left.
You raise your revenue, and you're going to lose licensees, and you're going to have fewer future licensees because of the high cost. Thank you very much.
And I do not see any other request for public comment. Shall I close the Q&A feature?
Yes, thank you. And thank you everyone for your comments. Item number 9 of the agenda, I would like to invite the Department of Consumer Affairs Legislative Office to present the legislative update.
Good afternoon, Chair, members, and Chief May. Can everybody hear me okay? Awesome. My name is Gregory Prudent. I'm a legislative manager with the Department of Consumer Affairs, and I'm here to provide the legislative update on agenda item number 9. In your materials, you have my materials. So if you'd like to view those, as we work through them, that would be helpful. We're working on 2 documents. I believe it's on page 9 of your packet, and then there is a addendum document that is additional materials, agenda item 9. So those items I will be covering. The first bill that we have on our agenda for is AB 1060, this conservators and guardians disposition of property. This bill would authorize a guardian or conservator to abandon valueless property only after providing a 15-day notice, and it would also authorize persons receiving that notice to petition the court to resolve a property dispute. This is a 2-year bill. It is in the second house, meaning it is currently in the Senate, and so the legislature has a little bit of time to act on this bill. So that is AB 1062, Mathis. AB 1662, Gibson, licensing boards, disqualification from licensure, criminal conviction. This is a newly introduced bill this year, 2022, and it would establish a pre-application process, essentially a process whereby a prospective applicant for licensure would be able to apply to the board and have the board determine prior to them applying for licensure whether they have criminal convictions or other issues in their past that would disqualify them from licensure. This bill has been referred to the Assembly Committee on Business and Professions and is awaiting a hearing date at the moment. AB 1663, Mindshine, protective proceedings. The information in your meeting materials on this one is slightly outdated because the bill was amended just 2 days ago on March 7th. But essentially what 1663 would attempt to do is establish a lesser restrictive form of conservatorship. Mindshine and his supporters are attempting to respond to some of the challenges that have been present in the state around conservatorships the last few years by establishing a process to have less restrictive conservatorships. This is quite a big bill. Among the amendments from 2 days ago, the bill now appropriates $10 million to the Judicial Council of California, who would be charged with establishing this less restrictive process. This bill has been referred to the Judiciary Committee and will be heard in that committee on the 15th of this month. AB 1733, Quirk, State Bodies, Open Meetings. My colleague Brian Clifford from the Executive Office briefly mentioned this bill a little bit earlier today. I would not anticipate this bill making its way to the governor's office before the end of this month. So as Brian and others have indicated, programs in the department should begin planning for the possibility of having to have an in-person meeting, at least until 1733 gets acted on by the governor. But given that we are at March 9th today, and this bill has not yet been set for a hearing in the legislature, it appears unlikely that this bill will be signed by the governor by the end of this month. SB 602, layered review of conservatorships care plans. This is where you will want to refer to the additional meeting material item for agenda item number 9. In that item, I've prepared a memo for the advisory committee on this issue. We were asked at a last advisory meeting to provide some information about SB 602 and the GC 355 form that is currently required and issued by the Judicial Council. And so I've put together a memo here to try to walk you guys through some of the differences between the existing GC 355 and what is proposed in SB 602. And so I'm going to be referring to this memo for the next few minutes. SB 602 would require a conservator within 30 days of appointment and 30 days before a hearing to submit a care plan regarding the care, custody, and control of the conservatee. The bill requires the Judicial Council to develop the form for this care plan. Additionally, the bill would impose sanctions for the failure to timely submit the care plan, including a penalty up to $5,000. And additional sanctions are also suspension or revocation of a license for failure to submit the care plan. So that's high level what 602 does. A little bit of background on these care plans. More than about 15 years ago, in 2006, a task force was established to review the court's role in conservatorships. A series of recommendations were made following the task force work, including the adoption of care plans and an existing level of care evaluation with the care plan into one form was one of the recommendations. However, most of these recommendations were never codified in statute. Existing law does require a conservator to submit an inventory and appraisal of the conservatee's assets within 90 days of appointment. This is in Probate Code Section 2610. And that statute required the Judicial Council to develop a form by Jan 1 of 2008 regarding this inventory and appraisal requirement. In practice, this form is referred to as the GC 355. And according to the Judicial Council, it requires a conservator's determination to include an evaluation of the level of care that existed when the petition for the appointment was filed, and the steps that would be necessary to keep the conservatee in his or her personal residence. The conservator must reevaluate the conservatee's placement and level of care when a significant change occurs in the circumstances affecting the conservatee's need for placement and care. However, these reevaluations are not currently required to be filed with the court, and there is no court form for them. But the Judicial Council does encourage conservators to make a decision about whether they want to file a reevaluation as part of any accounting pursuant to their role as the conservator of the estate. Importantly, some local courts, some county courts, do require a more specific, more detailed care plan. And if the local court does require such a care plan, conservators must comply with that additional requirement in addition to the filing of the GC 355. Again, as I mentioned just a moment ago, 602 would make some quite significant changes with respect to this existing process. Number one, it would require within 30 days of appointment or 30 days before a hearing, that a conservator submit a care plan for the care, custody, and control of the conservatee. This care plan, as proposed by SB 602, has some specific information that would be required to be included. The memo outlines it here, but in a nutshell, you would need to be providing information around their medication and medical devices, descriptions about their current level of care, any anticipated changes to that level of care over the next year. There would also need to be information around the conservator's schedule of visitation with the conservatee, description around the conservatee's normal activities, information around the conservatee's financial needs, including monthly income and expenses, information around assets that may be sold within the next year and the reasons for that sale, and then information around other valuable assets inside the residence that need to be protected and what steps the conservator is taking to do so. The information required by SB 602 appears to go quite significantly beyond what is currently required in the GC 355. Importantly, the bill SB 602 includes shall include but not be limited to language. This may allow the Judicial Council, when they're going through their process to develop this form, to require more information on that form than what is specifically prescribed in the bill. It does not appear that SB 602 repeals the current GC 355 form. Again, that form is located in Probate Code Section 2610, and it is unclear as well whether the form required by this bill, SB 602, would replace the GC 355 or if both would be required. I mentioned just a moment ago that some county local courts have issued plans which require more detailed information than what exists on the GC 355. And in some cases, these local county plans may require more detailed information than what is even proposed by SB 602. It's also unclear in SB 602 whether the form required by SB 602 would replace any of these existing local plans. In the materials that we've prepared here for you, we've included two examples of local county plans, one from Los Angeles County and one from Marin County. The Marin County form, for example, requires a conservatorship general plan. They require that to be submitted within 90 days of the appointment. And that general plan requires some pretty highly detailed information to be included. It includes very detailed information about monthly sources of income and monthly expenses, as well as the frequency of visits that the conservator would make. Some of this information, such as the schedule of visitation and perhaps some of the income and expenditure information, does appear to be required by SB 602. But other items that are located or, required in the Marin County plan appear to go beyond what would be required by SB 602. So for example, the Marin County plan requires information about items held in safety deposit boxes and information around IHSS or Medi-Cal benefits. Neither of this information appears to be specifically required by SB 602. Again, it is unclear whether if SB 602 passes and if a conservator is located in a local county that does require a local plan, it's unclear whether all three forms would need to be required. A GC 355, a local form, and this new SB 602 plan. Some other important differences between the SB 602 proposed form and the current GC 355 are around the civil penalties. SB 602 would allow for an up to $5,000 penalty if the care plan is not timely submitted. It also provides that the failure to submit the form is a basis to remove the conservator. And if the conservator is a professional fiduciary, They may additionally be subject to an administrative penalty, suspension, or revocation. The GC 35 is required to be filed under penalty of perjury, but the law does not appear to allow for any civil penalty for failing to do so, as SB 602 would provide. The local plans that I mentioned for LA County and Marin County are also required to be filed under penalty of perjury. In our memo, we've put together just a little chart here for perhaps ease of viewing some of these changes. I'm not going to go over them here in detail, as I've already mentioned many of them, but a lot of these differences are around days to submit, whether you have to do additional reports or not, the penalties, and then again, as we've talked about, the specific pieces of information that each care plan appears to require do appear to me, at least, to be different across the 602, the GC 355, and then some of these local plans. Again, as I've mentioned, we've included a variety of examples in the meeting materials. We have a GC 355, and we also have included plans for LA and Marin County. That concludes my presentation of the GC 355 SB 602 differences. I'd be happy to answer or address as best as I can any questions regarding any of the bills that I've mentioned, including the presentation on SB 602 and the GC 355.
Thank you, Gregory. Do we have any comments from committee members?
Hi, this is Wendy Hatch, and of course I have to weigh in on this thing. And Mr. Pardon, thank you so much for putting that memorandum together. It was very clear and precise. Some of my concerns coming from our position as the consumer protection area for our seniors. In the proposed 602, it says that it has to list the conservatee's health status, including medication, medical services, needs, as well as their healthcare providers. To me, that's really infringing on HIPAA privacy. And we're here to protect our seniors, and not are the only one that I see on the proposal as being confidential is the Marin County one, where it says at the actual bottom, confidential. So, and then my next concern is for the consumer, the cost. The cost of the conservator to prepare within 30 days, and usually lately we haven't even been getting our letters of conservatorship within 30 days of the hearing, but to prepare an inventory and appraisement, get it to our attorney, and have it filed within 30 days. That's kind of asking a lot. And our client, the conservatee, has to pay for our time, the attorney's time, and filing fee with the courts. And then in less than 9 months or 10 months later, when we're filing our first account current, the consumer is again going to have to pay for the conservator to prepare this plan, the attorney's time, and filing with the courts. The system of setting up the care plan and then following up with the accounting kind of goes hand in hand, because first you're telling the court, okay, this is where we begin. And then when you file your first accounting, you're telling the court what has happened in this past year. Do we actually have to have another form telling the court what's been done or happened, and again at the cost of the conservatee? And then once these forms are filed with the court, who's going to follow up with them? Is it the court investigator, or again, the private conservatee's information is being filed and put out in the public, and we have to protect our seniors' privacy on this. And I just don't know if a 602 sometimes might be just a knee-jerk reaction from a bad experience, but I would love to sit down with the author and see, because like you said, we have the state one, Los Angeles has theirs, Marin has one, so who do we follow? But that's my comment. Wait, let me make sure I have everything. The HIPAA and the penalties. I mean, if us as private professionals, if something isn't done, we're either fined or our license is taken away. And all I can say is sometimes even dentists or practitioners or something like that forget to do something and they don't lose their license and or get surcharged by their licensing bureau. So that's all I have. Thank you.
I appreciate your comments, Wendy. One of the things that I would just respond back to you in regards to what you just mentioned is, when conducting this research and looking, looking into this issue and sort of reviewing the sort of three different plans, right? The GC 355, some of these local plans, and then what's being proposed in 602. One of the things that very obviously jumped out is the differences around the length of time that one would have to prepare and provide these plans. It wasn't, wasn't lost on me that with the Marin County example, they're allowing 90 days. And if you look over what they're requiring in that document, some very, very specific, information that I would imagine requires having to track down and get files and make phone calls to get information and whatnot. And perhaps that's why they allow 3 months for that information to be provided. The GC 355 is less sort of specific, less detailed in sort of my review of it, and they allow 60 days. And then SB 602 seems to kind of split the difference, if you will, right? It doesn't appear to go as far as Marin, for example, but does go further than the GC 355, and it's 30 days. So it's a more detailed form, it would appear, with a much more aggressive due date. So I think some of the issues that you've raised are fair and appropriate.
And to follow up with like even Marin's file, where they get so detailed items found in the safety deposit box, that would all be on the inventory and appraisement that is filed within 90 days. I mean, we have to account for every penny in cash that we find in the house, in jewelry or whatever stocks and bonds that are found in a safety deposit box. It's on the inventory and appraisement. Why are we costing the consumer double work?
Thank you, Wendy. Any other comments from committee members?
This is public member Berta Sanchez Hayden. I also wanted to thank you for the thorough memo and for doing the research. And my impression from the memo is that the legislature is not very making a distinction between family conservators and professional conservators, but requiring that same level of information and those same penalties. Would that be your assessment?
I think that's fair.
And is it, with all of the current legislation, my impression also is that there's not been an adoption of taking an investigatory time in order, like in the previous, in 2007, when the investigations were done and there were substantive expert matters to look into the matters and then give recommendations. It's, did you find that in AB 1662 or SB 602, those types of investigations are being done for more pulling the issues in the community?
I appreciate the question. Are you referring to like how there was this task force that existed 15 or so years ago and that some of these recommendations came out of that task force? Is that what you're sort of asking about?
Exactly. Like, for example, the memo that you put it together, like really talking about the appropriate determination of a proposed conservative care. And I appreciate that all of us in this field are committed to making sure that somebody that's vulnerable is as protected as possible. And I think we want to see value added in the system that we're all part of. But one of the things that I'm looking at is to learn if that kind of task force is being done, because I can, as a seeing people file GC 335, I can see how complicated it is for family members to understand what a professional assessment is when their child might be severely impacted by a developmental disability. And if somebody's on public benefits, they don't, their idea of a professional assessment might be different than somebody that's placed in a long-term secure perimeter dealing with dementia. And it just seems like these distinctions of the, I guess I was just asking if you feel like there's distinctions that are being made in the cross population by having these, that might be come out by having task force comment or on the proposed legislations?
I think it's a really, really good question that you're asking. I'm not aware of any, big task force that's happened since '06. I wasn't able to find that in my research. That's not to say that there hasn't been. It's very possible. I'm just not aware of it or couldn't find it. I do think, you mentioned 1662, and in that one, really trying to come up with this new sort of, less restrictive conservatorship process that's being sort of designed in that bill. I think that one really comes out of sort of the Britney Spears example and the issues that were there. One of the groups that I believe is the sponsor of 1662 is the Free Britney group. So that might help explain sort of where that one's coming from. But on the task force type question, yeah, I'm not aware that there's been another, sort of state level or major task force, much like this one back in '06 with, a series of pretty concrete, comprehensive recommendations. I'm just not aware that has happened since then.
Thank you.
Hi, Greg, this is Rebecca. I just wanted to confirm, I think you meant 1663.
Sorry, yeah,
It's not often we have two bill numbers right next to each other.
Yeah, I was referring, 1663, yes, I was referring to the conservatorship Mindshine bill, not the pre-application determination for, criminal issues.
I also wanted to chime in and thank you so much for that memo. This is, you've gone above and beyond with preparing this for the advisory committee. I am super grateful and appreciative that you took the time to do this research, and I know it's outside of your usual wheelhouse, and you did wonderfully. So thank you so much.
You're most welcome. I certainly should have given the disclaimer that I'm not an expert in this field, but the research was super interesting, and I was happy to do it for you guys.
Thank you. And I also appreciate Bertha's comments, because I think sometimes with the Bureau and the department, like our focus is on the clients that are served by our licensees. And sometimes we don't necessarily think about just the private citizens that are impacted by legislation wholly outside of our particular profession. So I think that was a good point to make about 602, and I appreciate that. And then one more comment about to follow up on what Ms. Hatch had mentioned. So it's not clear through SB 602 that these requirements would supersede existing requirements for care plans. And so I just wanted to echo that the costs for these care plans are ultimately borne by the conservatee and his or her estate. So I think that was also an excellent point that Ms. Hatch made, and I wanted to say I appreciated that. Thank you so much.
Thank you, everyone, for your comments. Do we have any comments from the public?
This is the moderator, and we are opening the Q&A feature of WebEx to accommodate public comment. If you'd like to make a comment on this issue, you can look for the question mark icon, typically in the lower right corner of your screen, or behind the 3-dot other options. If you're on a mobile device, type the word comment into the text box and click send. Or the other option is to raise your hand by clicking on the hand raise icon. It has recently moved to the bottom of the WebEx screen. Or if you're on a call-in user, you can hit *3 to raise your hand.
Madam Chair, this is Fred Chen, UDCA Legal. Just wanted to address one of the comments that was made in the last item regarding the availability of the budget document that was shown on the meeting screen. We checked, and that document is currently available in the Bureau's website in the meeting materials for today's meeting.
Thank you, Fred. And that's on the website, correct?
Yes, that's correct. It's in the file that has all the bureau's meeting materials for
Great,
today's
thank
meeting.
you. Thank you for clarifying.
And
Do
I
we
do
have
not
any-
have
Oh.
any requests for public comment, no. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Item number 10, Rebecca, would you please present the Bureau updates?
Thank you. In the spirit of returning to a previous item, I just wanted to confirm with the advisory committee members that no, there's no requirement for submitting a Form 700. And I appreciate Mr. Brian Clifford letting me know that. So the Bureau update. So the Bureau's starting with application licensing and enforcement statistics. Our most recent statistics can be found in the meeting materials if you'd like to follow along with me. As you can see, the format has changed quite a bit since our last meeting, and my hope is not only does it look good, but it conveys information that will be helpful to our advisory committee and to the public in understanding the volume of applications, renewals, and complaints processed by the Bureau. I want to thank our chair, Chi Elder, for her thoughtful suggestions on how to better convey pertinent information, and to Angela Quadra for running the reports and putting this information together. And of course, I also have to thank the department's Office of Publications team for making this document beautiful and easy to read. So that being said, before I launch into the statistics, if the advisory committee members have any suggestions on what information they'd like to see in the future, please let me know. As you know, these statistics are simply a metric to measure the work that the Bureau does, and it comes from the data the Bureau collects and can measure. So these licensing enforcement statistics are from July 1st, 2021 through January 31st, 2022. And before I get started, so we have, it's all for this current fiscal year from July 1, as I said, to January 31st. There are going to be a couple of statistics broken down into quarters because that's how the data is gathered. So on January 31st, 2022, we had issued a total of 1,295 licenses since the Bureau's inception in 2008. As of that day, we had 837 active licensees. For applications, in this current fiscal year, we have received 57 applications and we have issued 40 new licenses. So one of the new pieces of this statistics is the processing time for our complete application. So when we receive an application and it's complete, for the first quarter of this fiscal year, July through September, it took 25 days from the receipt of the application until the amount of time until the Bureau approved the applicant then to sit for the examination. And then once the applicant passed the exam, it took 22 days for the Bureau to issue a license. For quarter two, 23 days, October through December, 23 days from the date of receipt to the approval by Bureau staff to sit for the exam. And again, once the individual, the applicant, passed the exam, it took the Bureau 15 days to complete the application. So for renewals, we have processed in quarter one, 205 renewals, and in quarter two, 207 renewals were processed. And then for the timelines for processing for the first quarter, 27 days, and for quarter two, 15 days. So as you can tell, that is a decrease in processing time. I will talk about it a little bit further down in my update, but we have been asking licensees to email in their renewals, and we put that up on the website, and it has decreased the processing time. So we've been really happy to be able to report that to you. So for enforcement, we have received in this fiscal year 57 complaints. and we have closed 71 complaints. There's a breakdown here so that when we talk about the next statistic, which is the average days to close being 466, we have broken it down by fiscal year, the complaints that were closed in each year, just to give a better idea of how many old complaints we have closed versus the newer complaints that get closed. For fiscal year 18-19, there were 3, 19-20, 34, 20-21, 17, and in 21-22, 17 complaints. For the complaints that are still pending, as of January 31st, we had 99 complaints pending, and they are mostly from last fiscal year and this fiscal year, but there are a couple that are older. We have 5 from 18-19, 9 from 19-20, 45 from 2021, and 40 from 21-22. We have issued no citations and initiated no cases with the Attorney General this fiscal year. So it's a lot of new information. I don't know if anyone has questions. I thought I'd pause here before moving forward.
Thank you, Rebecca.
Right.
Do we have any comments from the committee members on the chart?
Good morning, it's Elizabeth Ichikawa. I don't have any questions, but I just want to comment that I really like being able to see the breakdown of when the fiscal year that complaints are closed and the ones that are still pending. I think that's very helpful. Thank you.
Thank you.
This is Jim Moore. I also would like to thank the Bureau for doing it this way. It makes it a lot easier to follow.
It's a lot of data, but it seems to be more helpful data.
It looks really good, and this is from Wendy. Good job, guys.
Thank you so much. So for outreach events, I had the pleasure of attending an event on January 12th by a group called SAC Fast, and they are a group that's formed by the Sacramento County Adult Protective Services, and they bring together local government entities to share best practices towards combating financial elder abuse. I was joined by our advisory committee member, Jim Moore, and it was super helpful to have him there to share his expertise on the profession itself. So if there are any outreach events that you would like the Bureau to attend, please send us an email to our fiduciary inbox. It's fiduciary@dca.ca.gov. Our newsletter, our most recent newsletter, was distributed to the interested parties list in early January and is available on the Bureau's website. We are working on the next newsletter now with an anticipated release of mid-year. If there's information that you believe would be good to communicate to the public and to our licensees via the newsletter, please do not hesitate to reach out to the Bureau. So moving forward to the strategic plan, professional education regulation and legislation and administration. So though we had planned to review each remaining goal within the Bureau's current strategic plan, it is now time for the Bureau to start preparing for its next strategic plan. Since we will be starting fresh with the new strategic plan, today I will provide an update regarding the last 3 goals related to professional education, legislation and regulations, and administration. After I provide an update on the current strategic plan, I will follow up with information regarding what the advisory committee members and the public can expect in regard to our next strategic plan. So we've had some middling success in meeting the last 3 goals of the current strategic plan related to professional education, legislation and regulations, and administration. Specific to professional education, these 3 objectives remain on the Bureau's to-do list, and we will definitely revisit them in our next strategic planning session. Under legislation and regulation, as you remember, we are in the process of meeting objectives 5.3 and 5.4, which is promulgating regulations to create retired and inactive license types and establishing client notification guidelines. We have not yet begun promulgating disciplinary guidelines as indicated in objective 5.5. As for objectives 5.1 and 5.2, Bureau staff are always reviewing statutes and regulations to identify improvements needed and to better meet our consumer protection mandate. Next year's sunset review will be a great opportunity for the Bureau to work with the administration and the legislature on enhancements to the Professional Fiduciaries Act. Lastly, under administration, the Bureau has met almost all of these objectives. Staff is continuously monitoring the budget and staffing levels as indicated in Objective 6.2. Staff has also created licensing and enforcement desk manuals and updates them continuously to ensure continuity in the event of staff departures for Objective 6.3. For Objective 6.4, the Bureau relies on the department's Consumer Information Center to answer the Bureau's phones and to assist consumers and licensees with their queries. Bureau staff trains CIC staff yearly to ensure that they have the tools to provide reliable customer service to the Bureau's consumers and licensees. CIC supervisors and Bureau staff also meet on an as-needed basis to update the training manual or processes or when any issues come up. For Objective 6.5, staff have attended third-party trainings when able to do so despite the pandemic. And as I have always tried to do with our advisory committee in both our meetings and in one-on-one meetings, is to meet Objective 6.1 to harness your knowledge and expertise to improve how the Bureau functions. So in regards to the new strategic plan, the Bureau met with the department's solid unit last week to discuss the schedule moving forward to ensure a new plan is in place by the end of the year. The new strategic plan will rely on input from the advisory committee members, Bureau and department staff, stakeholders, and the public to identify both the Bureau's strengths and weaknesses in meeting its mandated functions. Strategic planning will help us focus our time and resources in order to prioritize our work over the next 3 to 5 years, so your input is valuable. Specific to our advisory committee members, Solid staff will reach out to you individually to schedule interviews for late April. Solid is also creating a survey for other stakeholders and the public, which will go live after tax day. And as soon as the survey is ready, it will be emailed to the Bureau's interested parties list. If you'd like to participate in the Bureau's strategic planning survey, please sign up for the interested parties email list on the Bureau's website. So moving forward to website updates, Bureau staff are always making small changes here and there to the website. However, there are 2 substantive changes that have occurred since our last meeting. Each year, as a part of the renewal process, licensees are required to report the aggregate value of their client assets, and the Bureau is required to post this information to its website. However, our licensing software limited the amount to $99 million, and some licensees do manage higher amounts. The fix was more involved than I would have anticipated, but the department was able to implement this change for us in January, and now as renewals are processed, the aggregate client asset value posted to the website should be correct. Second, and I alluded to this earlier, the Bureau has revamped its application and renewal information page to better convey licensing requirements. And we have been encouraging licensees to submit their annual statements via email, and this information is now on the Bureau's website. And so the last item, the internal consultant update. So we were asked at the last meeting to agendize the internal consultant update at our last meeting. However, it's still under review by Bureau staff, and so I don't have an update today on this, and I'd like to bring this back at a future meeting. So that's it for my update. It's a lot. Please let me know if you have any questions.
Thank you, Rebecca. Do we have any questions or comments from committee members? Okay, thank you. Do we have any public comments?
And this is the moderator. We've opened up the Q&A feature to facilitate public comment. If you've got a comment on the Bureau updates, you can look for the question mark icon. Once you click that, you'll see a text box. Type the word comment and click send. If you're on a mobile device, the Q&A will be behind the 3-dot other options. And the other option, if you are a call-in user, is you can push *3 to raise your hand. I'll give people a moment to locate the Q&A feature. And I do not see any comments on the Bureau updates. Shall I close the Q&A feature?
Yes, thank you.
You're welcome.
And thank you, Rebecca. That was a great update. Item number 11 of the agenda. Rebecca, would you please open the discussion on strategic planning, item 3.5?
Thank you so much. So at each meeting, I ask our advisory committee members and the public to let the Bureau know if there are outreach events that the Bureau should be attending, the Bureau staff should attend. Clearly, the pandemic has prevented events where people gather in person, but there have been opportunities for online or virtual engagement. The silver lining with virtual events is the saving in travel costs, but virtual events don't seem to connect us directly with consumers, especially older Californians. I'd like to open up this discussion by asking our advisory committee members if they have any suggestions for increasing the Bureau's outreach efforts, particularly connecting Bureau staff with consumers. Clearly, this is something we will move to discuss or to look at a little more closely in our strategic plan. So there'll be more time for us to figure this out than just today.
This is Berta Sanchez Hayden, public member. Thank you for the question, Wendy. I'm sorry, I'm looking at the screen. Rebecca, I was going to say, I think doing outreach that involve social workers at hospitals are very powerful to connect and create the pipeline with community members directly. Often social workers at hospitals are a relied source of information for the community. And although it might at first might not be the working one-on-one with the older adult, it can sometimes create that infrastructure within the community to create reliable sources. And so the community knows where to turn to for reliable information.
This is Denise Nelson. I was just thinking every county has an adult protective service office or whatever, and many of them do outreach and have events and things, consumer protection days and things like that. I don't know whether it's possible that we could find all the agencies and their phone numbers and send out a flyer telling them that, we've got information that might be useful for their community.
This is Elizabeth Ichikawa. I'm just wondering if the Bureau has had contact with family justice centers in the counties in California, because they also serve the elder population, specifically elder abuse. I think they do work with adult protective services also, and they also put on outreach events and that are specifically designed to educate the elder population. And I know that they also, at least in our count in Solano County, they work with the different area. I don't remember the exact name, but the areas on aging population or nonprofits to get services to the elderly, and they might be another good source of helping to get out information.
Great. This is Berta Sanchez Hayden again. To build on the comments of my fellow committee members, I would say that some agencies have held their own virtual open house. and inviting interested stakeholders as well as community partners throughout. So although it's not an in-person event, it could be a good place to holding a virtual open house for the professional. Our own outreach event could be a powerful way to start building those connections with the different agencies or resources commented by previous committee members.
I was furiously taking notes. Thank you so much for the leads. If there's anything you see in particular, always just shoot me an email. But I've got some stuff, I've got some homework, so thank you.
This is Chi Elder, and I also want to just add to what my fellow committee members have already shared. I think having an engagement, a virtual engagement with local stakeholders that serve adults, senior populations, and so this is something that PFB that your team would be able to host, and then we can provide members of the committee, and public if they want to also invite key stakeholders. But those key stakeholders could include local municipal agencies that serve seniors, like Department of Aging, whether it's city or county, and various nonprofits as well that have senior programs, and then local community colleges that have certificates or programs that focus on serving seniors. I think all of those are potential stakeholders that could be invited to such a convening. Any other comments from committee members? Do we have any comments from the public?
This is the moderator, and we've opened up the Q&A feature of WebEx to facilitate public comment. If you have a comment on the outreach efforts, you can look for the question mark inside a box icon, typically at the bottom right of your WebEx screen, or behind the 3-dot other options if you're on a mobile device. Type the word comment into the text box and click send. If you are a call-in user, you can push *3 to raise your hand. And I do not see any requests for public comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
And thank you so much, Rebecca. Moving on to item number 12. Rebecca, would you please present the status of the Bureau's proposed rulemakings?
Thank you. So I have one update today related to our inactive and retired license type. Bureau and department staff met with the Office of Administrative Law on February 9th to discuss the Bureau's proposed inactive and retired license status regulation, and OAL had several substantive suggestions for improvement. Accordingly, the Bureau withdrew the regulation the following day with the intent of amending it to reflect OAL suggestions and to resubmit it after allowing for another public comment period. The Bureau is working with the department's legal staff to draft revised language, and as soon as it is filed with OAL, the public will be notified via the interested parties list.
Thank you. Do we have any Thank you. Do we have any comments from committee members? Thank you. Do we have any comments from the public?
And this is the moderator. We are opening the Q&A feature of WebEx to accommodate public comment. If you have anything you'd like to add, you can look for the question mark icon, typically in the lower right of your WebEx screen. Add the word comment into the text box and click send. or look for the raise hand icon, which is *3 if you are a calling user. And I do not see any requests for public comment at this time. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
And thank you, Rebecca. Item number 13 of the agenda. Angela, what items have you recorded from our meeting today for consideration to be included on future agendas?
Hello, I have not recorded any items to be considered for future agenda items. And if there's anything I missed, please let me know, or anything you've thought of.
Are there any other items the committee members would like to add? Thank you. Is there any public comment?
And this is the moderator. We have again opened the Q&A feature of WebEx for public comment. If you have a suggestion for a future agenda item, you can put the word comment into the text box and click send. If you're looking for the Q&A feature and you're on a mobile device, it is behind the 3-dot other options, or you can always either click *3 or click the hand icon at the bottom of the WebEx app to raise your hand, and we will recognize you then. And I do not see any requests for public comment. Shall I close that out?
Yes, thank you.
You're welcome.
And thank you, Angela. Item number 14. The following meeting dates have been scheduled for the 2022 calendar year. If you have a conflict with these proposed dates, please contact Angela Quadra. Any comment from committee members? Any public comment?
This is the moderator. If anyone has any comment on a proposed future meeting dates, you can look for the Q&A icon typically in the lower right corner of your WebEx screen, type the word comment into the text box and click send. Each person will have 2 minutes to speak. If you would like to raise your hand to make your comment, you may do that as well. And if you are a dial-up user, you can click *3 to raise your hand. And I do not see any requests for public comment. Shall I close that again?
Yes, thank you.
You're welcome.
And the time now is 11:44 a.m. And I'd like to adjourn this meeting.
Thank you.